Okay, it's already 14:03. Probably we can start the dialogue now. So good afternoon, good afternoon, ladies and gentlemen. Welcome to ILA Dialogue. My name is Christy, and it is my pleasure to be a moderator for this dialogue on an overview. Okay, an overview and prospect of human rights protections in respect of Myanmar coup. Well, first of all, I will briefly introduce to our three distinguished speakers. We have with us now Ambassador Abdul Qadir Jailani. He is currently Director General for Asia Pacific and Africa, Minister of Foreign Affairs, Republic of Indonesia. Thank you so much for your time, Pak Ambassador, Pak Dirjen. How should I call? Or probably Abah Kadir, maybe, yeah, because I used to call you very long time ago with Abah Kadir. But well, to make it short, is it fine for you if I call you just Pak Dirjen or Ambassador or Pak Kadir or okay, Pak Dirjen aja ya. Okay. Pak Kadir, thank you so much for your time. I know you've been very busy these days because of the Palestine issue. I saw your face on the television many times to discuss about the Palestinian as representative from Indonesia. But today, well, we are not going to talk about the Palestine, but we are going to talk about another very interesting issue that we should discuss and address under the perspective of international law, that is Myanmar case. So I really look forward to have your opinion and also your view with regard to that issue. And then could you please share the Okay, so Ambassador Abdul Qadir Jailani is currently a Director General for Asia, Pacific, and Africa, a Minister of Foreign Affairs of the Republic of Indonesia. Before, Pak Dirjen was the ambassador of the Republic of Indonesia to Canada. And then before the ambassador, he was also the conjent, yeah, general consulate of the Republic of Indonesia in New York. And then a lot of professional career that I cannot mention one by one. But Pak Kadir, thank you so much for your time. And then Pak Kadir graduated from University of Erlangga for the bachelor degree and also Master of Law from the University of Indonesia and also Master of European Law and Policy from Portsmouth University. Thank you so much, Pak Kadir. And then we have second speaker here.
I think so, Bucharest have freeze.
Oh, is it mute? Yeah. I it's
You were freeze, Bucharest.
so sorry. I have a problem with the signal, I think. So okay. Uh okay, I already introduced Pak Kadir or I it's still mute. It was still mute, Bu Orin.
It's okay. You can just continue.
Okay, so I can continue with Bayuyun, yeah? Okay, sorry for that trouble. Okay, Mbak Yuyun. Okay, Mbak Yuyun will be the second speaker. High Excellency Yuyun Wahyuningrum. So Mbak Yuyun, is it okay if I call you Mbak Yuyun or should I call you High Excellency Yuyun? Okay, Mbak Yuyun. Okay, thank you so much, Mbak Yuyun. So Mbak Yuyun is a representative of Indonesia to ASEAN Intergovernmental Commissions of Human Rights, ICHR, yeah, to make it short, ICHR. So and Mbak Yuyun also have like very long professional career with regard to the ASEAN and human rights. So as you probably see in the screen. So, and then Bayun also a PhD candidate at the Global Governance, Law and Social Justice at the International Institute of Social Studies in The Hague, Erasmus University Notre Dame, 2016 onwards. So probably soon you will graduate it as a PhD, I think, hopefully. And also MA, Human Rights at the Mahidol University, Thailand, 2007, and got a diploma library science from University of Indonesia. Thank you so much, Mayun, for your time. And then for the third speaker, we have Professor Kees Flinterman. I'm very happy that you finally can come and be one of the speakers in our event, Professor, because it's been a while since our last meeting in Maastricht back in 2007. And then we really look forward to have your views since you're the professor of international law and also human rights law. So finally, we found a proper issues that we can have your view with regard to the Myanmar case. And for those who still do not know who is Professor Keys, he is the professor of human rights and emeritus professor of constitutional and international law, and he obtained LLM degree from Leiden University, University of Virginia, and PhD degree from Leiden University. And Professor Kees Flinterman is one of the founder of the Faculty of Law Maastricht University. And then also I was there in the Master University, and I saw one of the chair written Kees Flinterman there. So I mean, he's very important. He played a very important role in the establishment of the Faculty of Law Maastricht University, and he's also one of the dean from the period 1918 six, yeah. 1984 to 1986 in a law faculty of Master University. So thank you so much, Professor Kies, for your time. It is quite early in the morning in the Netherlands, but then you are here with us, so thank you so much. And then I also want to greet the participants. We have our colleagues from International Law Department today. Thank you so much for your time, and also participants from other university, from other institution as well, and also the students. Thank you so much for your time. I hope this event will be a benefit for you. Okay, and then before starting the dialogue, I will give the I would like to invite Professor Atip as our head of department and also the president of the International Law Association's Indonesian branch, ILA Indonesian branch, to open the dialogue and also give a brief introductions about what is International Law Associations and about our branch. For Professor Atip, you have 5 minutes for the opening speech, please.
Thank you, Bu Christy, and good afternoon for all of you, and good morning, special for Professor Kees. And first thing first, I'd like to express my sincere thanks, sincere gratitude to speakers today, Ambassador Abdul Qadir Jailani, and currently he is a General Director for Asia Pacific and African Affairs, Ministry of Foreign Affairs of the Republic of Indonesia. And second speaker, Ibu Yun Wahyuningrum, ASEAN Intergovernmental Commission on Human Rights Representative, and Professor Kees Flinterman from the Netherlands Institute of Human Rights. Furthermore, I would like to introduce briefly about international law associations and ILA branch Indonesia in particular. The International Law Association was founded in Brussels in 1873, and I think that this is the oldest associations, professional associations on international law. The main objectives of these associations are the study, clarification, and development of international law, both public and private, and the furtherance of international understanding and respect for international law. The International Law Association has a consultative status as an international non-governmental organization with a number of United Nations specialized agencies. And much of study reports from the this association has been main reference to much of International Court of Justice judgment. And ILA Brands Indonesia was founded in 2015. Yeah. And this is it's very historical moment, especially for Professor Keys when we uh, involved in NUVIC program and SWAMs of the programs, yeah, of the NUVIC cooperations between UNPAD and NUVIC is the establishments of ILA Brands Indonesia. Yeah. And ILA Brands Indonesia is the first brands, ILA brands in ASEAN. Yeah. And in organizing uh, the ILA Brands Indonesia program, especially in the era of COVID-19, ILA Brands Indonesia, in cooperation with international departments, Faculty of Law, Pajajaran University, organized two YouTube channels, yeah, namely Pajajaran Dialektika and ILA Dialogue. Pelajaran Dialektika organizes discussions on international law topics that are related or mostly related to Indonesian issues. While ILA Dialogues, yeah, organize discussions on contemporary international topic that's which invites, yeah, speakers not only from Indonesia but also experts from abroad, yeah, such as in this today discussion. And I think this is the second rounds of the ILA dialogues, yeah. And today's topic is very topical, yeah, and controversial, yeah, because Myanmar is one of the ASEAN members, and ASEAN's always been regarded as maybe we call it ASEAN way, yeah, ASEAN way, which always notes to determinative decisions in deal with issues, especially in the human rights issues. Mm-hmm. And as President of ILA Brands Indonesia, I'd like once again, I'd like to express my sincere gratitude to the source persons today, yeah, Pak Kadir, Ibu Yuyun, and Professor Kis Peterman. Thank you.
Okay, thank you so much, Professor, for your opening speech. I just want to make sure that I'm not in the mute. Okay, thank you so much for your opening speech. And then just want to add some information about the ILA Indonesian branch because I'm acting as the secretary of the ILA Indonesian branch. For those of you who haven't joined these organizations, please feel free to join and to register as our branch member. And then just send an email. Yeah, it's mentions there in the screen to info ILA Indonesian branch, and then just say in that email that you are going to join the member, and we will directly reply that email with the registration form that you should fill. And also there is some registration fee that you have to pay. It is not from us but from the ILA headquarters. It is necessary to pay the £30 for the membership of ILA headquarters. But for the branch, we don't ask for the extra fee for that, so it's still free. You just have to pay £30 for the membership in ILA headquarters. So that's about the short explanations about how to be the members of ILA Indonesian branch. So you cannot join the ILA headquarters because since ILA have the branch in every of the states, so you have to join the branch to be the member of the ILA headquarters. Okay, so that's about the ILA. So now we can start the discussions. Just a very brief introductions about what happened in Myanmar. Since the military coup, 1st February, I think, Over, like 250 people have been unlawfully killed, most of them during the protests against the impunity there, against the junta. And there has been also accusations of using the very excessive use of force against the civilians and especially the protester. So more than 2,000 activists, protesters, and politicians have been arbitrarily detained, and also journalists have been targeted. And the military has amended laws to impose restrictions on civic space and impose internet blackouts. So, despite the intimidation and violence by the security forces, the anti-coup protests continue. And so, if the situation continues to deteriorate, so the conflict could be escalate to the civil war, and there also some fear that Myanmar will be at risk of becoming a failed state. So, regarding that issues, I would like to invite the first speaker, Abah Kadir, Pak Dirjen, Ambassador Kadir, to share your view. Especially, we have already conducted the ASEAN Summit last April, if I'm not mistaken, and it was initiated by Indonesia to discuss specifically about Myanmar issue. So, could you please share to us about the result of the ASEAN Summit and how significant is that to the peaceful settlement of dispute in Myanmar? And also, as we probably know that Indonesia is one of the most vocal state that keep pushing the government, the Myanmar government, the junta, I mean government, to settle the dispute peacefully. And since you are inviting the senior general of the Myanmar, what's the name? Min Aung Hlaing, uh, to the ASEAN summit. So there is a strong criticisms from the civil organizations with regard to their presence in Indonesia, because they're afraid that that kind of presence will give impressions that Indonesia give the legitimations to the governments. And also there's also some question why you are also not inviting the unity government, what's the name, yeah, the Aung San Suu Kyi government that has been overthrown by the junta, to make it more impartial. So I really look forward to have your response to that criticism. So Pak Kadir, you have 20 minutes for the presentations, please.
Thank you, Bu Christy. Can you hear me?
Yes, very loud and clear.
Thank you so much. Good afternoon, everybody. Bu Christy, Pak Professor Atip, and Bu Yuyun, and Professor Kees. It's very nice to meet you all today. As explained earlier, that I'm requested to make a very short presentation on the recent situation in Myanmar, but because this forum is essentially attended by mostly by law students, so it is my intention to focus on the legal aspect on the recent situation in Myanmar, and of course, I would also like to talk a little bit about the rules of Indonesia in addressing the situation in the country. Can we go to the next slide? Okay, I will start by telling you a little bit the outline of my presentation. I will divide it into 6 parts. The first part, it will begin with a brief on the current situation in Myanmar. And second, the issue of illegality of coup d'etat will be an interesting issue to discuss today. And third, I should also present some legal provision on coup d'etat as enshrined in some international organization, charter, or constitution. And fourth, I would be remiss my duty if I don't discuss the principle of constitutional government in the ASEAN Charter. Fifth, it is also important to look how the UN and ASEAN mechanism will possibly deal with the situation in Myanmar. And last but not least, I should also like highlight Indonesian role and position on the current crisis in Myanmar. On the next slide, I think Bu Christy already briefly explains a little bit about the situation. And you know that the situation in Myanmar becomes a serious crisis when the military declared a state of emergency. You know, they argued there was no coup d'etat, and it was just the declaration of state of emergency, and it has been done in accordance with, according to them, in accordance with its constitution. And the consequences is that the military junta control on the 1st February, following the general election, which Madam Aung Suu Kyi parties, or we call it NLD, won the general election by a landslide. And not only that, the military also detained all the NLD leaders. The situation has led to a large scale of protests over the coup. It has been the biggest since the so-called Saffron Revolution in 2007. And according to my note, as of 25th of May, there are more than 827 people have been killed. And as a response to this situation, the parliament members that have been deposed by the military have aligned themselves by establishing CPRH and fought against the military junta. And not only that, with a view to seeking national support for establishing a national government, the CPRH established an interim union government, and its charter would serve as the new constitutional framework. However, until today, I don't have sufficient information that the interim government enjoys a wide all support from the armed ethnic groups and the NLD. And despite all international pressure, the military keep cracking down all the democratic civilian movement. The military is fully aware that the coup is a very drastic movement that put them in a position of point of no return. They don't have other option to offer other than zero-sum game. This is the very unfortunate situation. Therefore, at this juncture, it is hardly possible to envisage there is a change in the ground in the very near future. It will only be plausible if there is significant change on the situation on the ground that would serve as a catalyst to the current situation. And this is my brief exposition on what is the current situation in Myanmar. Can we go to the next slide, please? Now, in this slide, I wish to share with you my concise analysis on the illegality of coup d'etat in international law. And it is actually, I'm trying to focus on whether coup d'etat is prohibited or is allowed under international law. Despite there is a shared view among scholars on the illegal nature of the act, international law actually does not provide categorical answer on this question, whether coup d'etat is categorically prohibited under international law. During the Cold War, I should say there is a relative tolerance to the act of coup d'etat. We know that there are no explicit legal provision in multilateral convention prohibiting specifically coup d'etat. But the situation is a bit different. After the Cold War, the situation became very much different. International community accepts the legitimacy of government is no longer a domestic matter. Most post-Cold War scholars recognize what the so-called the principle of democratic entitlement applicable to in international relation. Most states agree that the failure to meet the principle may constitute an infringement of international obligation. Despite the new trend, the attitude of the UN Security Council to coup remains inconsistent. The response of the Council to a coup will be essentially determined by its assessment on the basis whether the coup constitutes a threat to peace and security. Of course, at the end of the day, the attitude of the Security Council would be mainly subject to strategical calculation of the interests of the permanent members of the Security Council. This is the normative situation of the act of coup d'etat at the global level. And now, in the next slide, I will show you the application of democratic principle, as I mentioned earlier, is not without a challenge. The cardinal principle of international law, we know that always include the principle of sovereign equality, that all states are equal. And international law also recognized as one of the pillar of international law, as it's enshrined in UN Charter, the principle of non-intervention. The application of the democratic principle should also be implemented in the light of the two principles. We cannot say that democratic principle shall prevail over the two cardinal principles. Even at the same time, we cannot say that the sovereignty and also the non-intervention principle shall compromise democratic or human rights principle at the same time. So in my view, all those cardinal principles of international law, they are all equally important. In this issue, I just want to refer to a case in International Court of Justice. I think the decision of the case is quite interesting because in Nicaragua case, the ICJ maintained that the establishment of totalitarian communist dictatorship does not constitute a violation of international law. It's very interesting, a decision of international court. Another challenge is that the application of democratic principles is unfortunately always subject to political convenience of states. Therefore, there are indeed a deep inconsistencies in its application. This uncertainty is reflected in the declaration of the high-level meeting of the General Assembly on the rule of law at the national level and international level. This declaration does contain prohibition of unconstitutional change of government. It only provides commitment to promote rule of law in accordance with national strategies. So if you look at this declaration, there is no prohibition of the unconstitutional change of the government. Only commitment. They leave it to the respective national strategies to decide how the principle of rule of law will be carried out. Now we go to the next slide. As I told you that I'm going to show you how some regional organizations addressed the issue of coup d'etat. Let's look at Article 30 of the Constitution of the Act of the African Union. In African Union, it is clear that a government coming to power through unconstitutional means shall not be allowed to participate in the activities of the African Union. So the language is pretty much different if we compare to what happened at multilateral level. At regional level, there is a prohibition of the accounts. Actually, it's not prohibition, but there is a legal consequences for the member of the African Union if they going through unconstitutional means, unconstitutional change of government, they are not going to be allowed to participate in the activities of the African Union. Similarly, in the Organization of American States, a member of the organization whose democratically constituted government has been overthrown by use of force may be suspended for participating to the meeting of the organization. And just a minute. And unfortunately, there is no similar provision in ASEAN Charter. If you compare with ASEAN Charter, there is no such provision. An ASEAN Charter only contains obligation to act in accordance with the principle of democracy, rule of law, and constitutionalism. So you know the difference, the situation, or the normative situation on the issue of coup d'etat, on the unconstitutional government, on the three regional organizations. And ASEAN has its own approach. And in the next slide, I will focus on how this provision is being interpreted. Next slide, please. The principle of the constitutional government in ASEAN Charter is indeed a legal obligation. Of course, a violation to this principle shall certainly constitute a serious breach of ASEAN Charter. There is such provision, despite there is no any clear legal consequences or suspension as the consequences of the violation. But still, I should say there are some practical problems to operationalize this legal obligation. In the Charter, it is not clear how can a serious breach be established. Does seriousness of breach, the seriousness of the nature of the seriousness of the breach, refer to a breach of a specific provision of ASEAN Charter, or does it refer to the nature of a particular breach? It is not clear. Not only that, it is also there is no clarity on who has the authority to establish that a serious breach has indeed occurred. Would it be arbitrarily established by any member states or by decision on an arbitration tribunal? In other words, can we say that, so what happened in Myanmar is a violation, a serious breach of charter? Can any other member state can say that, or we should bring it to arbitration tribunal as provided for in the charter? And what will be the legal consequences of such serious breach of ASEAN Charter? As I told you, for sure, we all know there is no suspension clause in the ASEAN Charter, as the case of African Union and the Organization of American States. Can we go to the next charter, please? At this slide, I think we should go on how the UN can possibly respond to the situation in Myanmar. I think it's very important to look at this possible scenario, how the UN will respond. I intentionally to discuss this because there are many people think that maybe UN can do better than ASEAN because there are many skepticism to ASEAN. So they think that UN might be a good place because UN can impose sanction or even R2P, as many people talk about in the last few days. I think this is a good topic to discuss. First and foremost is, of course, the Security Council holds the primary responsibility to maintain international peace and security. It is the most important institution. I met many people suggesting that the Security Council adopt R2P to deal with the situation in Myanmar. I promptly respond this suggestion by saying that we don't want Myanmar becomes another Libya. This is my prompt response. We have learned from many interventions that such enforcement measures do not bring any good. Therefore, R2P is certainly not desirable in this juncture. Please don't misinterpret my statement as if I'm defending what's going on in Myanmar. What I'm trying to say is that R2P is not a good solution. There are even more suggesting that the UN Security Council imposing sanction against Myanmar. For this idea, we don't believe that sanction would effectively change the behavior of the military. If we look at from what happened in the past, sanction only brings the pain to the people rather than to the military. Myanmar has been under sanction for many years from many countries, but nothing really changed on the ground. So if we impose just another sanction, it doesn't add anything to resolve the problem. More importantly, the Security Council will not be in the position to take bold measures against Myanmar as China and Russia will oppose it. And for your information, until today, Security Councils has not done anything but issuing a press statement. Now let's look at on the UN General Assembly. It is true that the UN General Assembly can also do something. It is now preparing a resolution which also support measures taken by ASEAN. They are still preparing, still being cooked, the resolution. I think it will come out uh, in the very near future. And the resolution essentially tries to delegitimize the military or the MD and support for CPRH. And one point I would like to stress is the UN General Assembly resolution does not have binding nature to the UN member states. So if General Assembly can come up with a resolution, it only add the political pressure to Myanmar, and it will add the political support to ASEAN. This is what we expect, but we cannot expect more than that.
Pak Kadir, sorry to interrupt. You have 5 minutes to go.
Okay. Last but not least, the UN Human Council also issued resolution on Myanmar. It has adopted 2 resolutions, and we can expect another 1 month. And how about on ASEAN mechanism? There are legal mechanism, there is a political mechanism. For legal mechanism is quite complicated because you may invoke the ASEAN Charter dispute settlement mechanism, but it's very difficult. But we think political mechanism is more desirable. As you know that we have convened informal ASEAN minister meeting and ASEAN leaders meeting. Next slide, please. And if you closely follow the outcome of the ASEAN leaders meeting, we have a 5-point consensus, and you can read it. And then next slide, please. On Indonesia rules. The Indonesia rules is Indonesia's leading role in the UN ASEAN fora is very clear that we did a series of subtle diplomacy with all parties and stakeholders in Myanmar. To Indonesia, safety and well-being of Myanmar people is the #1 priority. And restoring democracy and improvement of the human condition is a must. We are doing this also for maintaining peace and security in the region. And all those objectives can only be achieved if the 5-point consensus, as I indicated earlier, is effectively implemented. I thank you, Bu Christie. Sorry for going the time allocated to me. Thank you so much.
Thank you so much, Pak Dirjen, for your very interesting presentations and that from that presentation, it is clear that we cannot just directly say that this kind of coup is violated international law because there's no clear legal provisions that prohibit that kind of act. Yeah, just the coup d'etat per se, but not the violence and also the killing of the civilian. Of course, it's crystal clear that it is violated international law, but the coup itself or unconstitutionally changing the governments, it's not crystal clear whether it is violated the international law or no. And then also Pak Kadir already emphasized about the five apa ya Pak Kadir tadi? Five
Point
what
consensus.
5 points of consensus as a result of the Asian leaders in last April, and hopefully that Indonesia can play that the shuttle diplomacy, yeah, to make that kind of 5 point of consensus effectively complied, effectively uh, effectively apa ya effectively complied with uh, and then can give the significant contributions to the peaceful settlement of dispute in Myanmar. Yeah. That's a very interesting point of view because you also addressed that through UN Security Council, especially about R2P, you didn't agree with that because yeah, lesser than two evils. Yeah, people keep saying that R2P is lesser than two evils. And then also about the approach of the sanctions and economic sanction is not really effective for stopping the violence in Myanmar. But then I really look forward to having the view from Mbak Yuyun as a representative from the Asian Intergovernmental Commissions uh, of Human Rights that has a mandate written in ASEAN Charter to promote and protect ASEAN fundamental human rights of ASEAN people. Meanwhile, in that region, there is now an ongoing violations and also the killing against the civilian population in Myanmar. So how then these organizations should response to that violations, and we're also aware that this organization has a limited mandate and functions as a consultative organizations, but then in other hand this organization has a very heavy burden to guarantee the protection of human rights in ASEAN people especially. So please Mayun, you have 20 minutes for your presentations. Thank you.
Thank you, Ibu Christy. Good afternoon, everyone. I also would like to greet the other speakers, Ambassador Abdul Qadir Jailani, and also Pak Keys, Professor Keys from Maastricht University. Thank you very much for having me here. I've prepared my presentation to make my talk more focused, so I would like to share screen from here.
Please. Yes.
Okay, so I was asked to talk about the human rights part of the coup. But first, I would like to introduce the ICHR in case any of you may not familiar with ICHR. But if you are, then I'm sorry. So this is going to be redundant. ICHR was established on 23rd of October 2009. Now it's actually 12 years. It was established by Article 14 of the ASEAN Charter. So ICHR is charter body in ASEAN. It works based on the term of reference. It mentioned that our function is around 14 mandates. I will be talking about in the next slide later on the mandates. A member of ICHR consists of 10 ASEAN member states. So we are 10 representatives from 10 members. And we report to the foreign ministers every year, usually every July or August during the ASEAN ministerial meeting. According to our TOR, ICHR meet twice in a year, but in the last couple of 6 years, we meet 4 times in a year. Our ways of working follow the way ASEAN work. We are working based on consensus, consultation, non-interference principle, evolutionary approach, and it is consultative and intergovernmental body. I mentioned earlier that ICHR has 14 mandates, but to make it easier, I put them together into six mandates. Actually, you can lamp down all the 14 into six. First is on standard setting, cooperation and policy support, protection, human rights strategy, research and capacity building, dialogue and engagement. If you may ask, what is the role of ICHR in relation to the right of migrant workers or the right to prevent torture or on the situation of Myanmar? So perhaps the easiest way of providing that kind of questions is that ICHR has responsibility to develop standard norms to come up with the cooperation on human rights, policy support for ASEAN member states, policy support for ASEAN sector bodies, establishing a protection, a human rights strategy, research and capacity building, dialogue and engagement. The implementation somehow rather slow and sometimes difficult, but these are the summary of what ICHR mandate so far, according to the TOR. Now, let's look at Myanmar as our meat of our discussion today. Myanmar has ratified at least four international human rights convention, International Covenant on Economic, Social, Cultural Rights, CRC, the Convention on the Right of the Child, CEDAW on women, and CRPD on the right of person with disabilities. Myanmar also the state party to the ILO conventions, such as on forced labor, freedom of association, and protection of the right to organize, minimum age, as well as the worst form of child labor convention. Myanmar is state party to genocide convention. Uh, 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 Back to the question in relation to human rights violation during the coup. Um, I myself made some monitoring since February 1st. I also have an intern to help me to do the monitoring of the situation in Myanmar. According to the assistant of the Association of the Assistant of Political Prisoners, I think Pa Jalini also made the quote or refer to this data. Since 1st February 2021, there were 828 killed by military junta. 5,441 people were arrested, and human rights violation that had been documented so far. But mind you that we are monitoring the situation from what we've received on the media and also social media. So this information coming from the second source of information rather than the first source of information. Number of NGOs sending me a lot of reports in relation to the situation in Myanmar too. So we found prosecution in forced disappearances, torture, sexual harassment against female detainees, arbitrary detention, summary execution, killings of protesters, violence against the press, freedom of the press, violence against access to information, as well as digital rights. And there has been number of incidences in relation to looting and property destruction, especially public properties such as hospitals, market, and many other establishments. Since the perpetrators allegedly coming from military, so we can make a temporary conclusion or view or perspective that these all violations are coordinated, organized, systematic, and widespread, and known by the leaders of the military. There has been inadequate access to detainees. Again, we continue to receive a lot of reports in relation to sexual harassment against female detainees. Um, Initially, we look at the pattern of the arrests: journalists, students, protesters, activists, monks, politicians. But at some point, this pattern is not necessarily relevant because junta arrest anyone, a housewife, even so many different kind of profession and background. the use of weapons, grenade, rubber bullets, live bullets, and tear gas. In number of provinces or ethnic areas, they use. I'm not familiar with the name of the bomb, but we have gathered all the information. Media only allowed to be published, such as Global New Light of Myanmar, Myanmar News Agencies, Miyawadi TV. These are army-controlled media, and the escalation of violence increase the threat of safety of humanitarian operation. So at the moment, there the UN bodies, UN offices having their humanitarian operation in different part of Myanmar. There has been number of incidences in relation to displacement, food insecurity, access to healthcare, education system, and so on and so on. So these are the data I gathered from the OCHA in Myanmar. As Pak Kadir mentioned earlier, ASEAN has responded to the situation by 5-point consensus on 24th of April. But before that, ASEAN also come up with the ASEAN Chairman Statement on the 1st February. So the coup was announced in the morning of the 1st February, but ASEAN already come up with a statement in the afternoon of 1st February. And as you may seen in the media, Minister Ratno has been doing the shuttle diplomacy, doing a lot of lobbies, phone call, and to different diplomats, different leaders. On the 2nd of March, ASEAN also come up with another chairman statement as a result of the informal foreign ministers meeting. And as we all know, then on 24th of April, another chairman statement was also published by ASEAN and come up with the 5-point of consensus. Coordination and communication was implemented, as we all perhaps see. If you check the Twitter of Minister Retno or the Instagram of Minister Retno, of Foreign Minister of Indonesia, you might have a lot of information in relation to whom that she has been talking about the situation and who has been lobbied in relation to the situation of Myanmar. Because there has been number of accusation that it has been there is a dualism in terms of responding Myanmar. I do not see that way, because I think Minister Ratno has been actively doing a lot of work in terms of informing national and then communicating with the peers in ASEAN, as well as making communication to international community. Even before and after 24th of April, a number of individual ASEAN member states have been making some connection to CRPH, committee representative of Pidongsu Hutlo. This is the parliament, and also the NUG, the National Unity Government. So for those who are confused about CRPH and NUG, CRPH is like a interim parliament, and then NUG is the interim government. Now both of them are in exile. Myself, I also make some connection to CRPH and NUG, especially for those who I know from my previous engagement in civil society. So what has been the response from ICHR, given that given ICHR has a limitation? On the ICHR has come up with press statement, but unfortunately it was only signed by 4 countries: Indonesia, Malaysia, Thailand, and Singapore. This was initiative from Indonesia, so I was the one who proposed having this kind of intervention and table the statement that was released on 5th of February 2021. And then during our 33rd meeting of ICHR on the 6th to 8th April, we also managed to convince all ICHR to accept an additional agenda, which is agenda item 15 on current development of human rights in ASEAN. So for the history of ICHR, this is something, this is milestone, this is a breakthrough, because in the last 12 years, ICHR has not been able to talk about human rights situation in its formal setting. We talk about human rights situation, we talk about human rights issues in our workshops, seminars, conferences, but not in our official meeting. So the inclusion of this agenda is actually the acceptance that it is the time for ICHR to talk about it. And this is the initiative from Indonesia. We insisted to have this particular agenda. And it is also the implementation of the TOR Article 4.10 to obtain information from member states. For your information, Indonesia has been pushing for the implementation of Article 4.10 in the past. So for instance, in 2013, Indonesia organized the ASEAN Human Rights Dialogue, which has been called as the mini UPR, to present this is what has been achieved in the last I don't know, years for certain countries, and then having response from different countries. In 2013, Indonesia, the one voluntarily expressed and presented the development of human rights post the reform, and Indonesia received a lot of comments, questions, and it was rather a different way of engaging human rights in ASEAN. It was the first step, and we would like to continue that kind of engagement. And a part of having that specific event, we also wanted to have something more uh, as a standing agenda of the ASEAN, of the ICHR, and we managed to have this agenda item 15 on the current development of human rights in ASEAN. In that time, on the 8th of April, 6 countries made intervention. So as you can see, on the 5th of May, of the 5th of February, there was only 4 countries making expressing their concerns in relation to the situation in Myanmar. But on the 8th of April, 6 countries making some intervention concerns in relation to Myanmar, which is Indonesia, Malaysia, Thailand, Singapore, Vietnam, and the Philippines. The rest 4 did not say something differently, so we assume that there has been a silent consensus on the situation. And then we also debated on whether or not we need to reflect what we have discussed in the press release, and all member states agreed. So it has been reflected in our press release on the 9th of April. And additionally, ICHR also agreed to stand ready to help Myanmar on the task given by the ASEAN foreign ministers. This is also the implementation of the TOR Article 4.14 of the mandate of ICHR. The summary report later on will be reflecting what we have discussed. What happened after ASEAN leaders meeting? As we know from the media, after Eid, there will be a visit. I'm not sure will or is visiting Myanmar, consists of Foreign Minister of Brunei, former Foreign Minister of Indonesia, Pak Hassan Wirayuda, and also the former Vice Foreign Minister of Thailand, Wirasak Phutrakul. AHA Center, as of now, is coordinating with different and relevant institutions to prepare humanitarian assistance, as well as perhaps ASEAN now is talking about the appointment of a special envoy. Perhaps you may also ask, because General Min Aung Hlaing said in the media, as quoted in the media, that there will be no envoy, there will be no visit until the situation in Myanmar got stabilized. But as you can see in the 5-point consensus, there are at least 3 main actors. First is Tatmadaw, second chair, and then the third is AHA Center. So despite the fact that General Min Aung Hlaing said something differently from what he has agreed in Jakarta, the 2 actors can continue working to continue make some preparation. What would be ICHR role? So there has been a number of practices in different part of the world when there is a crisis, either political crisis or armed crisis. The Human Rights Commission has been not included or difficult to find their role during the crisis. But after the crisis, then usually a number of efforts can be initiated. But I think ICHR can play some roles in this situation, especially to help and to contribute to the implementation of the 5 point of consensus. First, ICHR can provide human rights perspective into how AHA Center can operate the humanitarian assistance. ICHR also can provide human rights perspective to the special envoy and to actually be part of the team. The 5 point consensus mentioned about a special envoy. So it is singular rather than plural. But in the previous practices, the late Surin Pitsuwan, the Secretary General of ASEAN, he was appointed as special envoy to Nargis in Myanmar, and he established his own team consists of different people to reach out to different groups in Myanmar in that time. So that kind of uh, mechanism can also be used. And as mentioned in the press release of ICHR, ICHR stand ready to be given any task by foreign ministers to help the situation in Myanmar. ICHR may also host a regional consultation to gather inputs from the people in the region, especially in Myanmar, especially those who are not heard during this processes. So these are something that ICHR can do. But individually, we have been raised awareness about the Myanmar crisis during our lectures, interview with media, lectures, social media, and many other channels that we can use. Um, and we monitor the situation in Myanmar very closely and coordinate with different institutions, especially national human institutions in the region. So that I've been coordinating with different national human institutions on how mechanism of human rights, be it is national or regional, can respond to the situation in Myanmar. And some this is my last slide. Some suggestion to the envoy. I think the envoy need to have an effective mandates and should have specific priorities with the relevant stakeholders. Ensure the ability to work together within and among different groups and issues. As we know, the stakeholders, actors in Myanmar is rather complex. The envoy need to address this kind of complexity to engage with people or groups in Myanmar. And number of people underestimated the power of humanitarian assistance. As you can see in the press briefing of Foreign Minister of Indonesia on the 2nd of March, it mentioned about humanitarian access to include visiting political detainees and then vaccine cooperation. So these actually can be included or to widen the concept of humanitarian assistance. Uh, in the past, in the history of Myanmar, humanitarian assistance to Cyclone Nargis has opened up uh, political opportunities and political spaces among civil societies to engage with governments. So I'm actually hopeful with this humanitarian assistance and humanitarian assistance approach will able to expand or open up number of possibilities beyond humanitarian, beyond logistic, but rather on also political space and political opportunities. Thank you very much.
Well, thank you so much for the very interesting presentations by Yuyun. I hope it is clear for all the students here and also for the all participants uh, when they're wondering about the concrete actions that has been taken by the IHR with regard to the issues of the Myanmar, and also the role of the IHR itself. So already explained very clear by Yuyun, and also the suggestion for the humanitarian assistance approach to open the relations between the civil organization and the political society, the political government there, uh, to make it more smooth, yeah, through the humanitarian assistance. Thank you so much, Mayuyun. And now I would like to invite my third speaker, Professor Kees Flinterman, a professor in international law and also human rights law. So, Professor, I would like to know further about the prospect of the human rights enforcement with regard to the Myanmar case, and then what kind of the mechanism available under international law that can be uh, taken to solve the problems. And also probably you can also respond to Kadir's statement about the human rights security council mechanisms that seems to be not very effective according to Pak Kadir. And also there's also the possibility for from the civil organizations to bring the perpetrator of the violation in Myanmar before the International Criminal Court through United Nations Security Council resolutions. So, how do you respond to that? And also your perspective as a as a uh, as a expert from the Europe, yeah, probably you can make a comparisons the EU mechanisms with the ASEAN and make some suggestion the appropriate measure that should be taken by the ASEAN as the regional organization. Please, Professor, you have 20 minutes also for the presentations.
Thank, thank you very much. And first of all, I would like um, to thank you very much for the invitation to participate in this very important seminar on the Myanmar coup, which is of so much concern not only to the ASEAN region, but I think to the whole international community. I listened. Secondly, I have to apologize that I don't have a PowerPoint presentation. I listened carefully to the very interesting and informative presentations by Ambassador Kadir and Ambassador Yuyun. Um, and I'm impressed by what has been achieved so far within the context of ASEAN, the 5 points consensus, and the role that the ISA is playing despite its limited mandate. I've been asked to address the Myanmar coup from the point of international human rights law. And what I would like to do is to add the international human rights law dimension to what has been said so far, um, and focus on the possibilities and the tools that are available within the United Nations system to address the situation in Myanmar. I do agree that with Ambassador Kadir, that the role of the Security Council in this respect is very limited indeed, and that the invocation to invoke the principle of the responsibility to protect, although legitimate, is implying quite a few challenges and dangers for international peace. But before addressing the possible mechanisms of the United Nations, let me say a few words about the normative framework that has been created since the establishment of the United Nations in 1945, the normative framework in the field of human rights. As you know, the United Nations was established in order to maintain peace and security around the world. to promote economic, social development and to promote and protect human rights. And the first step that was taken by the international community, by the United Nations at the time, was the adoption of the Universal Declaration of Human Rights. In the Charter itself, there is no list of human rights, but that was provided in the Universal Declaration of Human Rights. The Charter itself stipulates that all member states of the United Nations should work individually and jointly in order to realize the objectives of the United Nations. Well, the Universal Declaration of Human Rights has become the basis of 10 core human rights treaties at the international level. Uh, and already reference has been made to the fact that the ratification record, the record of ratification by ASEAN states, is somewhat mixed, and that Myanmar is only a party to 3 out of the 10 international human rights treaties: CEDAW, the Women's Convention, the Convention on Economic, Social and Cultural Rights, the Convention on the Rights of the Child, and the Convention on the Rights of Disabled Persons. And what is important, and what is also, I think, a cause of concern, that Myanmar has not accepted any individual communication procedure, has not accepted any procedure by which individuals within the country can submit a claim to an international supervisory body in order to hold their states accountable. I'm very pleased that already in 1993, at the time of the World Conference on Human Rights, the second World Conference on Human Rights in Vienna, the ASEAN states, although they have a mixed record of ratification of human rights treaties, have stipulated, have confirmed that the universality of all human rights is beyond question. And have also said that in implementing human rights and fundamental freedoms, the particular characteristics of each and every state should always be borne in mind. Particular characteristics relating to the culture, the religion, the political system in the country. And they have also recognized at the time, in 1993 in Vienna, that human rights are a legitimate international concern. And I was also pleased to see that in the ASEAN Declaration on Human Rights, which was adopted in 2012, once again, the ASEAN member states reaffirmed their commitment to the Universal Declaration of Human Rights, the Charter of the United Nations, the Vienna Declaration and Program of Action, and other international human rights instruments to which ASEAN states are members. And it is therefore my submission to you that the ASEAN Declaration on Human Rights should be seen, should be interpreted against the backdrop of the Universal Declaration of Human Rights and the international instruments which are based on the Universal Declaration. And what is important, that in the framework of the United Nations, the member states have not only adopted a normative framework, but have also provided for a system of supervision, for a number of supervisory mechanisms in order to see to it that the obligations that states have incurred through their membership of the United Nations and through their ratification of international human rights instruments are indeed living up, are complying with their obligations. And those supervisory mechanisms can be divided into political monitoring mechanisms in which the Human Rights Council of the United Nations, a political organ, is playing the crucial role, and in legal monitoring mechanisms. Legal monitoring mechanisms, I will come back to it in a minute, which are provided for in the human rights treaties of the United Nations. The political mechanisms, as I said, um, in the hands of the United Nations Human Rights Council, an intergovernmental body of the United Nations, which is the primary organ in the field of human rights within the United Nations. And it's interesting that this political organ has adopted a procedure by which each and every state is held accountable for its human rights performance every 4 years, the so-called Universal Periodic Review. And it's somewhat cynical that Myanmar was subjected to a review of its human rights obligations just before the coup on the 1st of February this year. But what is also important is that the United Nations Human Rights Council has followed up on the practice of the United Nations Commission on Human Rights and has established a large number of special rapporteurs, independent persons, independent experts who, on behalf of the United Nations Commission on Human Rights, monitor uh, the compliance with human rights obligations by states around the world. And those special rapporteurs can be divided into country rapporteurs and thematic rapporteurs. Country rapporteurs, and Myanmar is one of the countries which has been subjected to such a country rapporteur since the early 90s. An independent rapporteur who, since 1992, is following very closely the development of human rights in Myanmar, and who is submitting regularly reports to the Human Rights Council and the General Assembly of the United Nations, the Third Committee, on the human rights situation in Myanmar. He can be addressed by individuals, by non-governmental organizations in Myanmar. He is easily accessible, and his information is at the basis of the resolutions to which Ambassador Kadir also referred on Myanmar. And it's very important because by monitoring the situation of human rights, documentation can be prepared, which in due time could also play a role in other fora. And I will come to that later on, and that is the International Criminal Court in The Hague, which has been established in 1998 and which has been mandated to prosecute leaders who have been accused of gross violations of human rights. And there is no doubt that there are such gross violations taking place in Myanmar. And not only is there the country rapporteur, as I said, there is a long list of so-called thematic rapporteurs who, on different issues of human rights protection, such as the freedom of expression, such as arbitrary detention, are collecting information about violations of such rights coming from all parts of the world, including Myanmar. And again, that's important to know for those who are now suffering under human rights violations in Myanmar, that they can always address the United Nations. And what I would like to emphasize here is that the Human Rights Council is assisted in its work by independent experts, both serving as country rapporteurs and as thematic rapporteurs on various issues of human rights protection. And then the legal protection. Interesting is that at the international level, the 9 human rights treaties that have been adopted each provide for a body of independent experts, and that means experts who are not under government instructions, who address the situation of human rights in the countries, in the states that have ratified such human rights instruments. And unfortunately, as I said, Myanmar is only a party to a limited number of those human rights instruments. But nevertheless, it's important to know that there is that possibility to address international fora. And let me also address very briefly the International Criminal Court in The Hague. Once again, the statute, the statute of the International Criminal Court has only been has not been ratified by Myanmar. But nevertheless, it is possible for the prosecutor of the International Criminal Court to start independently an investigation of gross human rights violations, and then submit this case to the International Court of to the International Criminal Court. And in discussion, I could further elaborate on that particular issue. My conclusions, then we have time for discussions. First of all, I think it's the primary responsibility of ASEAN as a region to address the situation of human rights in Myanmar. The role of the United Nations is very important but limited. Once again, I agree with Ambassador Kadir that the role of the Security Council is limited in this respect, and that the emphasis should be on the discussions and the diplomacy in the context of the Human Rights Council. And I find it very encouraging that the recent resolutions on Myanmar by the Human Rights Council have been adopted by consensus, including the member states of ASEAN who are members of the Human Rights Council. And I stop here because I have a cough, and I come back in the discussion after having muted myself. Apologies for that.
Thank you so much, Professor, for giving us a very detailed explanations about the works of Human Rights Council, and also to address that as a party of the and also to a very address or emphasizing a very important statement that the as a member of the UN and as a party of the many human rights conventions, the obligation of the state is not only adopting the normative rules, but also in that obligation as a party to the conventions, there's also supervising mechanisms that are monitoring and political mechanisms that all the states have to make a universal periodic review, and also being monitored by the supervisory body under the conventions. And that's also an obligation of the Myanmar to give the report to the commissions of the treaty by the under the conventions as the consequences of being the party of the human rights conventions. And also it is also there's the special rapporteur for the Myanmar since 1990s, you already said earlier, and also the thematic rapporteur by the freedom of expression for Myanmar. So yes, Myanmar has been monitored by the supervisory mechanism under the convention that it is already ratified. But if it's although it's not so many convention that Myanmar has been ratified. And also you already give your opinion about the ICC. Since Myanmar is not a party to the ICC, of course, the only mechanism to bring the perpetrator to the ICC is through the UN Security Council, because it is different compared to the case of the Rohingya, because as we probably aware, the Myanmar has also been investigated before the ICC through the Bangladesh as a state party for the Rohingya crisis there. But for this case, it's a bit different because Myanmar is not state party, and the territorial jurisdictions is in Myanmar, which is not a state party. So only through the UN Security Council, the perpetrator of the Myanmar can be brought before the ICC. Okay, so without further ado, I would like to invite all the participants to ask the questions to all the speakers. I believe all the speakers will be very happy to answer that questions. So I will give the first opportunity to the lecturer who would like to ask directly. Please unmute your speaker and you can ask directly. And also for the students, you can write down the question in the chat box. I will try my best to read all the questions and answer the questions before the dialogue ends at 4 o'clock in the afternoon. So please, who would like to ask first? We have, is there any lecturer that would like to ask first directly to the speakers here? Mm, oh, okay. If it's okay.
Christy,
Yeah.
I'm
Yes.
sorry. I'm looking for the raise hand feature, but I couldn't find it. Can I
There
ask?
is one, yeah, from Yogi. I
Yes.
think.
No,
Yeah.
no. I mean, like, I'd like to ask some or give some comments and maybe
Oh, I see. Okay, okay. Please,
question.
Borin. Yes, please, please.
Yeah, thank you very much for all the speakers, Pak Kadir, Bu Yun, and Professor Keys. Thank you very much for all the discussions. And I would like to highlight to the Hers, Mbak Yuyun. I think it's when I heard at first, I would like to say, of course, like honestly, like we're quite pessimist to the work of the ASEAN and also HR because we know that the limited mandate that the HRs has. But from your presentation, I think it's very good news. There are a lot of things that the HR has to work, and it seems like I don't know. Maybe you can like clarifications like crossing the boundaries of the HR mandate or how, because all of the things every time we discuss particularly about the human rights and law enforcement, it's always difficult for the ASEAN. And the CATET, the summit, last summit, which I call it as a sudden summit. I think it's also great initiatives and great for to discuss and to solve these issues within the ASEAN countries. So the issues that probably coming to us is we always like stumbled with the issues of the ASEAN way and the non-intervention. So can you probably explain us how can the HR did that without any protest of the violations of the non-interventions and also the ASEAN way? And also Pak Kadir, maybe from the perspective of the Indonesian government, Indonesia is quite what we call it brave or strong enough to try to enforce the human rights, particularly within the ASEAN countries. So maybe particularly Mbak Yuyun and Pak Kadir can give some insight for that, and also probably from Professor Keys also maybe would like to you have some point of view on that. Thank you.
Thank you, Mbak Dewi, for the questions. I think it is unfair to see ASEAN in black and white, despite the fact that ASEAN has non-interference principle as well as the mechanism of making decision in consensus. In my experience, I've been engaging ASEAN as civil society for some time and then now becoming part of the system. Non-interference principle, Pak Kadir may have some dimension. It's not always destructive. Sometimes it's also useful. Similarly with the consensus, I give the example of consensus first. Consensus is not a matter when you have enough time of discussion, but if you have timeline, for instance, when you discuss about the ASEAN Human Rights Declaration, you have to come up with the text by this time. There is a deadline and so on and so on. So in the end, the text will remove something that are not necessarily reaching consensus. But as a matter of fact, in ASEAN, in terms of, at least in my observation in relation to human rights document, as you can see, the characteristic of document is always um, not negotiation, is giving different kind of perspective. So the ASEAN Human Rights Declaration itself has number of limitation to human rights, but the Phnom Penh statement that uh, uh, that come along with the declaration mention and affirm the commitment of ASEAN member state to the international human rights law. So ASEAN always has this kind of dualism in terms of its approach into human rights. But I think that's reflecting the debates at some point at that current moment, or at the moment when the rights was discussed, and may go along the way in, and so the time may present you different kind of situation later on. In relation to, so another example in ICHR, uh, Indonesia's proposal to table on the discussion in relation to Rohingya, for instance, from 2019, even before, has been always meet with the non-consensus, non-interference principle argument. But uh, non-consensus is not something written down on the stone. If you do not get any consensus now, you table it again in the next meeting, table it again in the next meeting. That's in the situation in which you don't have deadline. In the case of introducing the agenda item 15, for instance, I think the escalation of violence contributed to the willingness of the rest of member states to agree to discuss about the situation. So when Indonesia tabled it for the first time, there was a rejection, of course, from the country in question. But then Indonesia insisted that we have to talk about this, and then until the day finally all agreed to come up with a with that kind of agenda. So there is a contribution of political opportunity. There is a contribution of the situation, political situation, that allow us to break down all the non-interference principle argument, or non-consensus argument. So I think that has been something. It is not like black and white. It is not yes or no. There are a number of factors contribute to the formulation of agreement or breaching the non-interference principle, and also the consensus. I do not reject the consensus way of making decision, because sometimes in ASEAN we are coming from different background, different political system, and different record of human rights and respect to human rights. Sometimes the suggestion may be contra to human rights principle. In that time, that Indonesia has to use the consensus argument by disagreeing on the idea that against the principle of human rights, because we cannot assume that all ideas, all proposal always supported human rights. So some Indonesia, well, of course I'm biased, but Indonesia always put all suggestion in relation to respecting human rights, implementing number of commitment in relation to human rights. Sometimes we got consensus, sometimes we don't. But again, it is not something written on the stone. So if we don't get any consensus now, we table it again and again and again and again until we got what we want in terms of respecting, protecting, fulfilling human rights at the regional level.
Okay, thank you, Mbak Yuyun. Pak Ambassador Kadir, please.
Thank you. I will jump in directly to the issue of skepticism to ASEAN, as Mbak Dewi just pointed out. I'm fully aware that now there are many people are quite skeptical to ASEAN. And to be honest, the skepticism is quite legitimate, And I do understand, but there is one thing that I would like to underline. It seems there is a misunderstanding. The problem is many people sometimes expect ASEAN to be what it is not. So my point is we should manage our expectation to ASEAN to be something what it is. We cannot expect a fish to fly, for sure. If you expect a fish to fly, it will never do it. And it is also the case for ASEAN. On consensus rule, many people also critical to the consensus rule. I know consensus rule has created some barrier, and it has created some barrier to our policy, to Indonesian policy. But to be honest, if we look at to the history, to a certain extent, ASEAN can survive because of this consensus rule. If there is no consensus rule, I'm not very 100% convinced that we can survive for more than 50 years. Yeah, I'm not convinced that. And you know that ASEAN has been one of the most successful regional organizations to maintain regional peace and security. Other than EU, you can compare to other regional organizations. Do you know what is the political dynamic of ASEAN in the 70s? And now ASEAN, Southeast Asia becomes one of the most stable region in the world. Now let's look at another problem. You mentioned about non-intervention principle and respect for sovereignty. Among many discussion, my impression is there is misunderstanding people who criticize on this as if the root causes of the structural limitation of ASEAN is because ASEAN adopting principle of non-intervention. I just want to tell you with you that non-intervention principle in respect for sovereignty is not unique to ASEAN. This principle is the most important fundamental principle. It's the first pillar of the existing international order. Even UN Charter, without sovereignty, without non-intervention, there is no this contemporary legal order. Non-intervention is not only in ASEAN Charter. We took it from the UN Charter. It is universally applicable principle among states. The only problems, as I mentioned in my presentation, how this principle, the principle of non-intervention and respect of sovereignty, will relate to another principles, such as the principle of respect for human rights and democracy. How it will talk each other, how it will come into play in the real life. To me, as I told you in my presentation, nowadays people believe that we cannot say that human rights or democracy shall prevail to a non-intervention. But of course, at the same time, we cannot say that we can tolerate human rights violation or a democratic human rights violation in the expense of. We cannot say that we respect the non-intervention sovereignty in the expense of human rights. To me, those two principles are equally important. So the more important thing is now for ASEAN, even in our position, we say that we do respect the territorial integrity. We respect the sovereignty of Myanmar. We also respect that we are not going to intervene the domestic matters. That's why we are always dealing with them. So there is always limit on what we can do. This is my first point. And the second point, if I just want to take this opportunity briefly, the question made by posed by Ibu Christie on the issue of recognition. I heard that many people pose a question why ASEAN invited a junta, because it will constitute a recognition. I just want to give you 2 point of views answers. One is strictly from legal point of view, and the second one is from political point of view. First, from legal point of view answer. To the extent of my knowledge, there is no international rules oblige countries to recognize or not to recognize. This is the first answer. Why you should push us to make a recognition or not to recognize? And the second thing, from political point of view, I have mentioned that even the minister herself mentioned many times that the focus of Indonesia is the well-being of the people of Myanmar. Their safety is #1 priority. And because of that, we do want to achieve cessation of hostilities and dialogue. And for that purpose, communication with all parties is inevitable. We need to engage everybody. We need to establish communication to pave the way the dialogue. Otherwise, there is no dialogue. And you know that the real problem is the military junta. The military junta, the one who did the violence. So we need to talk to them, not to talk to the CPRH. So this is the very idea, because we think more important to us to stop this. We just want to talk with military junta, just want to have a dialogue in order to pave the way cessation of hostilities. I thank you.
Thank you, Ambassador Kadir. Please, Professor Kiss.
Thank you very much. I have already indicated my appreciation for the role of ITSAR in the present crisis in Myanmar, despite its limited mandate. Very important, I think, efforts have been undertaken by the Commission, and I'm impressed by that. I do agree with Ambassador Kadir that the 2 principles of non-intervention and respect for sovereignty are key principles in international relations. Question is, of course, what exactly the scope is of the non-intervention principle. But he's quite right in saying that always these 2 principles have to be balanced with other principles, such as the respect for human rights and fundamental freedoms. And for that reason, I briefly indicated and quoted the Vienna Declaration on Human Rights of 1993, in which it was said that the protection and promotion of human rights is a legitimate international concern. That's one, and that means that the principle of non-intervention is not violated if other states are expressing their concern about developments in the field of human rights in other states. Share, because that's, I think, the essence of human rights treaties and human rights declarations, such as the Universal Declaration of Human Rights and the ASEAN Declaration. The protection and promotion is a joint concern, is a matter which is not only the responsibility of the state concerned, but which also affects other states. And it's, I think, from that perspective that ITSAR is playing a role. The experience in other parts of the world is that such commissions as ITSAR are playing an important role, but could even play a more important role, and I'm just raising that question, if they would be composed not of intergovernmental of governmental experts, but of independent experts. And if they could be addressed directly by the people affected, by the people violated in their human rights and fundamental freedoms. And I was wondering whether steps are underway in order to see to it that the normative basis within ASEAN in the field of human rights, which is now a declaration, a non-binding declaration, could be strengthened through a convention. And secondly, whether also steps are underway to transform the commission, the ITSAR, into a commission of experts. That's a question I would like to raise. Thank you.
Okay, well, probably Mayun can respond to the questions from Professor Kiss. Yes, please.
Thank you very much, Professor Kiss, on the two questions. The first one is on whether or not ASEAN Human Rights Declaration will be upgraded into legally binding framework. Since 2015, ASEAN ICHR has been discussing on possibilities to have legal framework on human rights in ASEAN. Number of discussion in relation to how to do this. So the idea of coming up with more legally binding document was agreed, but how to do it, this is something that require further discussion. Number of participants, for instance, in number of workshop and discussion organized by ICHR, come up with the idea perhaps there is a need to rather having a theme base of legally binding document. Participants in that time suggested perhaps on women and also on children on a number of issues. But at the moment, there has been number of differences on how to pick up the issues. My personal opinion, I don't think ICHR is ready or ASEAN is ready to come up with legally binding document on human rights. I have written this in an op-ed in 2016 um, because I think ICHR need to implement or to promote the implementation of the content in the ASEAN Human Rights Declaration first, to establish commitment, to establish foundation in which governments, member of ASEAN feel comfortable on rights inside the ASEAN Human Rights Declaration. I think ASEAN need to be given some time to come up with the legally binding document on human rights. Otherwise, it is going to be watered down as what we have experienced so far. But I think this time we need to use the time we have now. I don't know until when to familiarize ourselves to find our ways of interpreting and implementing what has been committed in the ASEAN Human Rights Declaration, and that exactly what ICHR is doing. ICHR now organized number of activities in relation to the implementation of Article 14 on the prevention and counter of torture. Article 23 on freedom of expression and opinion. Article 22 on freedom of religion and belief. Article 5 on the right to an effective remedy. Article 4 on number of issues under Article 4 because it has women, children, elderly, person with disabilities, and other vulnerable groups. I think we need to be able to identify what are the state obligations under each rights and what are rights actually as we imagine should be protected under this declaration. If these all clarified, I believe the path going to have the legally binding document on human rights becoming maybe smoother or better or easier. But I think what our strategy now is to provide rather interpretation on the implementation of the articles in the ASEAN Human Rights Declaration and to mainstream human rights in the ASEAN community. So these two approaches that we, two strategies that now implemented in ICHR through its activities. in relation to is there any possibility to transform ICHR into more commission of experts? Um, we supposed to have the review of the TOR in 2014 and in 2019, but the review not happening. But we continue. Indonesia has been committed for this because it was Indonesia the one in 2009 that pushed for a stronger commission because our National Human Rights Commission, Komnas HAM, is very strong. That is why we want to have a regional human rights mechanism as strong as the Komnas HAM. But in 2009, there was no consensus in relation to that kind of format. But we go what we go and we work based on what we have lah in 2009. So uh, we are looking at that direction, but the two processes that's supposed to be happen is not happening. But Indonesia has established number of ways toward that path through the 5-year work plan. Our 5-year work plan has number of elements to support the protection. For your information, the word protection itself has been removed from our 5-year work plan, but the elements of the protection have been included. For instance, grievance mechanism, complaints mechanism, monitoring of human rights, referral system. So number of things included there. So I think Indonesia has been very creative in looking at possibilities of providing a foundation in which all member states feel comfortable to talk about human rights as a substance, as a state obligation, a protection as the very mandate of the human rights mechanism. But unfortunately, in this region, to be able to arrive at that point, we need to establish the path. We need to establish the foundation to arrive at the situation or the condition or the objective that we would like to go.
Okay, thank you so much for the explanation by Yun. Yeah, I'm very interesting when all the speakers speaks about the interplay between the sovereignty, the principle of democracy, and also the principle of non-interventions. Well, what is the most interesting here is we do agree that this principle comes from international law. But what is important here that this principle is not without exceptions. So that's the reason why Ambassador Kadir said the balance between these principles with other principles like the democracy principles and also the sovereignty. And Professor Kirs also already emphasized that the state cannot say that his domestic affair has been violated or there is a violation of the non-intervention principles if there is a strong gross violations of human rights committed by the state and give the impact with the other state, especially if the state itself the party to the one conventions. So there is a violations of other obligations of the state, then the state has to give the responsibility for the violations. But Ambassador Kadir, I have a specific concern with regard to the statement of you saying that about the recognition or non-recognitions of the general what's the name? Yeah, that general that already presents in Indonesia, and there's a strong criticisms regarding that presents. My concern is okay. I mean, probably about the coup or the violations of the principles of international law is not very clear with regard to coup. But the fact that the journal itself has committed a strong violations of human rights, gross violations of human rights, killing like thousands of people. The fact that they are here in Indonesia, and then I do agree with you that the conflict the one that makes the conflict is the military. So we have to talk to the military for the sake of peace. So but again, you you have also considered the concerns of the human rights activists that what he has committed is a gross violation of human rights, and the victim needs justice. The fact that they are here and you just have a dialogue with him while people needs him to be brought before the justice, it's also something that you have to consider. So this is between peace and justice. So what do you think about it,
Thank you.
Ambassador. Yes.
I just want to have a quick response to your question about the presence of the Men Online in Jakarta, whether it constitutes a recognition or no. As I told you that, in my view, there is no provision, there is no any obligation in international law that compel Indonesia to issue a declaration whether we recognize or not to recognize. So we can be silent, and you may ask further why we are silent, because why you still communicate with them, and you know exactly that this military has committed human rights atrocities in Myanmar or whatever you say. Yes, you're right, but once again, we focus on the well-being. If we don't want to talk with him, and there is no dialogue, and no one will do something in Myanmar, and the atrocities just continue, nothing will stop. Now, let's look at today. Even Security Council can do nothing. Even UN can do something. Even EU can do something. So I think despite all the weaknesses, I would say that ASEAN is the place for to resolve the Myanmar issue. Because, and remember that with ASEAN centrality, all the key countries believe that only ASEAN can resolve this. We talk with China, we talk with India, with the US. Please look at it from the geopolitical dynamics perspective too. I'm not only looking at from the legal perspective, but let's look at it from the geopolitical dynamic. And ASEAN might be the best place. I know that Bu Yuyun would like to say something. Please, Bu. Silakan, Bu.
Silakan Bu Yuyun.
Thank you, Bu Christy, Pak Kadir. Diplomacy is very meticulous on choosing words. As you may identify or you notice that the name of the meeting is ASEAN Leaders Meeting. And ASEAN Leaders Meeting has no definition, fixed definition in the ASEAN vocabulary. If ASEAN, it is not ASEAN Summit as written by media. ASEAN Summit, according to Article 7, comprise of head of states. So the presence of the General Min Aung Hlaing was not recognized as the head of the state or government, but the head of the coup, which ASEAN member states need to talk to stop the violence, because you cannot talk to CRPH or NUG to stop violence because they are not committing the violence. So I think the way ASEAN has been choosing some words, texts, and ways of conveying something, all text has been picked very carefully to prevent of recognition, because as Pak Kadir mentioned, ASEAN is not in the position to recognize or not to recognize. Countries are not in the position to recognize and not recognize, but ASEAN believe that this is a very sensitive issue. It is therefore certain words have been mentioned. I also look at what Pak Jokowi mentioned. Pak Jokowi mentioned high level meeting, and Prime Minister Muhyiddin also mentioned about ASEAN leaders meeting. Prime Minister Singapore, Prime Minister Lee also mentioned about high level meeting or ASEAN leaders meeting. Brunei Sultan also mentioned about ASEAN leaders meeting. The word summit mentioned by the media, not by the diplomats or the officials. So that is why I understand there's for ASEAN certain words has a certain meaning, and they have been very carefully picking up some of the words. And the presence of Min Aung Hlaing in Jakarta was not to recognize or was not to legitimize Tatmadaw or SEC, but rather to talk to the person, to the institution that committed violence in the country.
If I may, Bu Christy, I just thank you so much, Bu Yuyun, for raising this point. It is quite a valid point. we name the meeting as a ASEAN leaders meeting. It was by design. It is well crafted with an intention, exactly for the reasons that Ibu Yuyun explained. And not only that, I just want to tell you during the meeting in ASEAN foreign minister, informal foreign minister meetings, even Ibu Retno never addressed Wuna as the foreign ministers. She only called him Mr. Wuna.
Okay.
Even during the meeting, the President Jokowi never say, and other leaders say, you are the head of state of Myanmar, the chief of the military of Myanmar. Because by law, formally, General Min Aung Hlaing is the chief of the military. So we address him, the chief of the military. So actually, we are sending a clear message without being trapped on the legal debate on recognition, because we are focusing how to resolve the situation on the ground.
And put aside the justice, no, because probably it doesn't give explicitly the recognitions of the governments. But what about the fact that it seems like you are okay with the violence?
No,
Because okay.
no, we are not fine with that. We are not blind to what happened on the ground. And by pursuing the political resolution, this is one way to pursue justice.
Okay.
The best way to pursue justice is to stop all the violence. We can talk later about what's going about whether we should bring all the perpetrators into trials or no. That's another story.
Okay.
But I think the more important thing is, and I'm telling you once again, sir, let's look at it from the political dynamic and geopolitical dynamic. Otherwise, we will never achieve the resolution. And do you remember my first slide? If we continue like this, and now we know there is no any adequate catalyst on the ground that will compel the military to change, nothing will happen. So we should do something, and we must be patient. Otherwise, we don't want to have a situation like in Middle East. We don't want to see like what happened in Libya, what happened in Syria, in Yemen, in Myanmar, because we have the interest. If there is a conflict like in the Middle East, we will be affected too. Thank you.
Yeah. Thank you, Ambassador. I want to give other opportunity for the participants to ask the questions directly, because I don't see any questions from the chat. Yeah, Yogi. Okay, please, Yogi.
Thank you very much. And thank you to all three speakers for this wonderful presentation. Due to the interest of time, just to ask a quick question, what role or what impact does the NUG, the National Unity Government, have in resolving this conflict? Is there a possibility that other countries may recognize the NUG as the legitimate government, just as some countries recognized Juan Guaido as the legitimate president of Venezuela when that crisis occurred, especially seeing that the military junta really has not implemented or has taken any steps towards committing to the 5-point consensus. I mean, we've seen reports that violence is still ongoing. So thank you very much.
I just want to add
See, if I may,
very just one. Okay.
Sorry, because maybe I should leave the
Oh,
meeting.
okay. Yes, please.
Can I respond directly, briefly?
Yeah, sure. Yes.
I think, how about what is the role of NUG? Of course, NUG will be key actors in the resolution. And if you can see that one of the element of the key of the 5-point consensus, we need to establish inclusive dialogues. We need to have dialogues with all stakeholders, including with NOG, also including with the ethnic groups, with everybody. So our main idea is to bring what the so-called Myanmar-led and Myanmar-owned dialogue. Thank you, Bu Christy. Maybe, sorry, I should apologize. I should go right now.
Okay, thank you so
Bye-bye.
much, Pak Kadir. Bye.
Bye-bye. Sorry.
Thank
Thank
you.
you so much, Professor.
That's okay.
Thank you so much, Bu Yuyun. Yo, bye-bye.
Thank you so much.
Thank you, Pak Kadir.
Bye.
Okay, please, Mayuyun, you can respond to the questions from Yogi.
As of now, I think NUG is developing its work. Yesterday, I talked to the Minister of Human Rights, and he has been very clear about what he has been given a task and mandate and priorities toward creating the new Myanmar. That's how the language has been introduced, and but they also need to work together as a team. The Minister of Human Rights, for instance, was appointed a little bit later than the initial structure of NUG, so they need to work together and how to complement each other. So I think we need to give them time. All of them now is in exile. So I think the way of working may be different from if you have a physical office or can making some direct project and activities in the country. But I think NUG is very important. In the beginning of the crisis, actually we have been very not confused. We have problem of looking at the actors in Myanmar, because in that time was only Tatmadaw and CDM. But then when CRPH was established, we are hopeful now we have actor, and then NUG was established. Now we are happy that we have more actors in it. We know, we recognize the ethnic groups also very important to play as in the reconciliation process and also the peace process inside the country. So now, if Myanmar will establish more and more organized groups, that would be useful for the envoy later on, as well as for the humanitarian assistant, because they know whom to talk to. Without the establishment of NUG or CRPH or others, you just imagine you enter the country but not knowing who to talk to. Now the creation of different actors identify themselves as very organized in a body or groups, that would be very helpful, and I'm sure they have ideas and have something to say on the betterment of Myanmar. I'm not sure which country in the world that have recognized NUG, but I saw number of online meeting with some European governments. I know some individual ASEAN members that also made some contact to NUG, but they prefer to be behind the scene because we are having this leverage, but also limitation by being ASEAN, by being in Southeast Asia. So connection continue to be maintained, but for NUG and ASEAN member state, I think they have been communicating behind the scene, not because I saw a number of pictures in social media of NUG, so they make some connection to different parliamentarian members, also with governments. But for ASEAN, I've never seen they have online meeting with ASEAN member states, but I believe the communication is actually happening, but but they prefer not to be make it public.
I think it's clear, yeah, Yogi, yeah? Thank you so much. And Professor Kiss, if you want to say something?
No, not on this point. I'm very pleased to hear that ISAR is in contact with OUG, but so far as I know, and no other government in the world has taken steps to recognize. And I think that would be, under the circumstances, not the best way forward. It's better to see them as an important source of information on what is happening on the ground in Myanmar.
Yeah. Okay, thank you so much. Well, we already running out of time. I'm sorry, I cannot keep my promise to finish the dialogue at 4 o'clock sharp. It's already 4:12. So my apologies for that. Probably I will give 1 minute for each of the speakers to give the final statement with regard to the Myanmar issues. Please, Bu Yun first, and then Professor Kiss after. Please, Bu Yun.
Thank you very much, Ayla and UNPAD for organizing this event. I think this is very important event to share our ideas about and clarify some of the issues in relation to the situation in Myanmar. I think Indonesia and ICER Indonesia continue to be committed to address the problem. We are not seeking solution is in Myanmar with the people in Myanmar, but I think the role of ASEAN and ICER is to facilitate the process of searching for solution. I think 5-point consensus deserve to be more to have more deepened understanding and implementation. The role of academic will be very useful as well to offer a definition on what should be what we should understand about humanitarian assistance in the crisis political crisis context, and also what should the special envoy do in this kind of political crisis such as in Myanmar. I think these inputs will be very useful for ASEAN, for the chair, and we know that this crisis not going to end by December. It is going to continue. So the chair will move. So the responsibility of uh, 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 um, uh, uh, not control to look at the issue will move from Brunei to Cambodia into 2022. If the crisis continue, then Indonesia will have the responsibility because Indonesia will be the chair in 2023. So if scholars will be able to help us as practitioners uh, in providing this kind of inputs, that perhaps that would be very useful. Cambodia has experience of dealing with Khmer Rouge. Indonesia also has a experience of dealing with a political crisis. So how inputs be contextualized into the benefit and the background of the country chairing in ASEAN in 2022 and 2023 for the benefit of the people in Myanmar.
Yeah. Okay. Thank you so much, Mbak Yuyun. And next, please, Professor Kiss.
And thank you very much. And once again, I would like to say how privileged I feel that I was part of this important dialogue. I learned a lot about the role of ASEAN and especially about the role of ITSAR. And I'm impressed by the activities which are underway. Still, there's also a role to play for the outside world, for the international community at large. We should not turn away from what's happening in Myanmar. What's happening there is a concern to ASEAN, but also a concern for the international community as a whole. The limited role that the United Nations could play should be played by the United Nations, by the Security Council, but especially by those organs of the United Nations that are primarily responsible in the field of human rights, such as the Third Committee of the General Assembly and the Human Rights Council. It's important to document what's happening there. Maybe for once there will be an opportunity at the international level to hold the leaders in Myanmar responsible, also criminally responsible for what's happening at the moment on the ground in Myanmar. But first also, it's the role of the international community to support ASEAN, to support the regional arrangement to address the situation in Myanmar and to find a way which gives hope to the people of Myanmar suffering once again. Thank you very much.
Thank you so much, Professor Case. And also, thank you so much for all the participants. Thank you so much for all the speakers for your time. I mean, all of you taking time out of your personal and professional to attend this dialogue. So I would like to express my gratitude for that. And also, yes, we hope that this dialogue can give the contributions to the stability of the region, ASEAN regions, hopefully, and then give the clarifications to the public what is real happening there and what is the role of the ICHR, of Indonesia, as well as of international law with regard to that issue. We have still our head of department here, Pak Atip. Can you please also close the sessions and giving some token of appreciation from all those two distinguished speakers here, Pak Atip, please?
Thank you, Bu Christy. Thank you very much for all participation and especially for the speakers, Professor Kees Peterman and Bu Yun, for sharing knowledge, ideas, and experience dealing with human rights, and especially in the hot issues in what happened in Myanmar. And international department of Pajar University are always committed in developing international law in both in theoretical and practical issues. And maybe we have provide other YouTube channels for competing issues or contesting issues. So we will be call it as ILA debate or maybe Pajajaran debate. Yeah. Once again, thank you very much for all participants and especially for speakers, Professor Kees and Ibu Yun. Thank you very much.
And we have also certificate, Prof. Atip. You can
Oh,
probably give the certificate to all the speakers. We have Pak
yes.
Kadir already left. And for Bu Yuyun, please. Yeah.
Yeah.
Yeah. This is also for Bu Yuyun and also for Professor Kiss.
Thank you.
Thank you so much for your time and for sharing your views with us. Okay, maybe we have to end the dialogue now. Thank you so much. Wishing you all the prosperity.